Good morning, students. Today I'm talking about the rights of a member. Rights of a member of the company, and who is called as a member of the company, whose name is registered into the members of the company. So that person is called as the member of the company. So member of the company may or may not be a shareholder of the company, but shareholder of the company whose name is in the registered members of the company, that person is called as the member of the company. So member of the company may ceases to be a shareholder of the company, but may be a member of the company. So member of the company may or may not be a shareholder of the company, but shareholder of the company is entitled to become a member of the company by having its name registered in the register of members of the company. So there are certain rights available to a member of the company. And when a person becomes a member, he is entitled to exercise all the rights of a member until he ceases to be a member. He ceases to be a member of the company. So, as a member of the company, you can exercise all the rights available to you as per the Companies Act 2013, the rights which are available to members of the company. You can exercise those rights as a member until you ceases to be a member of the company. And so long as a person name is registered in the books of member and register of members, or he or she has sold the share and has given a share certificate and the blank transfer deed duly signed, he alone is entitled to exercise the rights of membership unless and until it is replaced by the transferee, to whom you transfer your share certificate or whom you transfer your share warrant, the transferee. Unless and until your name is replaced by that person, you can enjoy your membership rights as a member of the company. Uh, so your name must be in the register of members in order to exercise your membership rights. So as soon as you become a member of the company, you can enjoy those rights. Uh, so there are certain rights, individual rights available to a member of the company, and this is mentioned. This is mentioned in the Companies Act. So we have to follow the provisions, compliance of the Companies Act to exercise those rights as a member of the company. So, number one right is to right to receive copies of certain documents. As a member, you have a right to receive copies of certain documents. The document is important documents of the company. This is your right. This is your right to receive copies as a member. Number one document is abridged financial statement. This is abridged is a brief, you can say, a financial statement of the company, and auditors report of the company. As a member, you have right to receive the copies of the auditor's report to or to verify, in order to inspect or investigate the books of accounts of the company or the reports of the company. You can avail that copy. You can, and company provides you copy as your member of the company. Company provides you a copy to see the records of the company, the financial statement of the company, the auditor's reports of the company. Second point in this, the report of the cost auditor is the copy of the report of the cost auditor, which you can receive as a member of the company. And the third is the notices of general meetings of the company. Notices of the general meeting of the company. The rights of a member. Uh, Number one right is already I have discussed. Right to receive copies of books of accounts, right to receive the auditor's reports, and a cost auditor report of the company, and then right to inspect statutory registers, returns, and get copies thereof. Right to receive, right to inspect statutory registers, returns, and get copies of statutory registers and returns. This is your right you have as a member of the company. The budget trustee, section 71, right to inspect register of charges, instrument of charges, section 85 and section 87. Right to inspect copies of contract of employment with managing or full-time directors. This is you can inspect. You can see the copies of contract of employment with managing or full-time director of the companies. And then shareholders minutes book section 119. Then register of contracts, which you can inspect, which you can investigate, which you can see. As a member of the company, it is your right to see, to inspect the register of contracts, which when company enters so many contracts with the suppliers, with the vendors and third parties, in respect to lease agreement or in respect of purchase of furnitures and fixtures, land agreement is there. So you have to right to inspect, investigate the register of contracts which companies signed with third parties. Then companies and firms in which directors are interested, section 189. So you can have a right to inspect these important documents of the company as per the section 189 of the Indian Companies Act 2013. So as a member of the company, you have a right to inspect the register of contracts signed by the company, contracts intended to by the company with other companies and other firms, with suppliers of the company, vendors of the company, and with third parties. So you have a right to know where company invests your hard-earned money. As a member of the company, as an investor of the company, you should know where transactions of the company during the years. As a member, it is your right to know. It is your right to inspect, investigate the important documents of the company as a matter of your knowledge, as a matter of your information. As an investor, you should know. As a shareholder of the company, member of the company, you should know. It is your right to know as per the section. So, right to inspect statutory registers and returns. This is the registers and returns and get copies. You can get a copy also. You can demand for the copy from the company. These contracts for inspection, investigation, verification purposes as a weird investor of the company. And the rights register of directors, you can get a copy, inspect these documents, register the directors of the company. And KMPs are there. KMPs is a key managerial person of the company, very, very important persons of the company, and their shareholdings. You can know, you should know on request, on demand to the company. You can know as per section 170 the copies of who are the key KMPs of the companies, and you should know as investor of the company as a right. This is your right. This is right you should avail as a member. This is your membership rights to inspect these important documents of the company, and you can demand a request to the company for to provide you copy to for your information purposes and for your verification investigation purposes. You can inspect you can demand for a copy. You can request for a copy to the company. Then again there's a right to attend meetings of the company. As a member, you have a right to attend all the meetings of the company, annual general meetings of the company, extraordinary general meetings of the company, class meetings of the company for the class shareholders. You have a right to attend meetings of the company. This is your right which you can avail, which you can enjoy as a member of the company. This is your right to attend meetings of shareholders and exercise voting rights at these meetings, either personally you attend or through proxy. You can appoint someone else on your behalf to attend your general meetings of the company. If it's company law to you, you can appoint proxy on your behalf. So that person represents you in person, and if it is allowed, if proxy is allowed by the company in general meetings, then you can authorize some person as your proxy to attend meetings on your behalf in person. If it's not possible for you to attend in person, you can allow another person to attend the meetings to see the workings of the shareholders meeting. Section 96, Section 100, Section 105, Section 107 that deals with the right to attend meetings with the shareholders and exercise voting rights in the meeting, either personally or through appointment of proxies in the meeting. These section provides you the right to attend the meetings of the company, and you are entitled to also to vote in the general meetings, either voting by hand, showing of hands, or voting by poll, or online voting is there, video conferencing is there, e-ballot system is there, electronic voting is there. So there are so many methods of voting uh, in the company. So you can exercise those voting rights as a member of the company, and only you can exercise these rights in the general meetings of the company. So other right is there. Other rights is there. That is to transfer shares, Section 44 and Section 56 and of Articles of Association of the company, to resist and safeguard against increase in his liability without his written consent. This is a section 44, Section 56 of the and the A of the company. These are the other rights which are available to the members of the company to transfer shares of the company. So this is right available to you, given to you by Section 44, Section 56 and AOA of the company, and to resist and safeguard against increase in his liability without his written consent. Uh, so you can avail these rights. So to receive dividend when declared, that is your right to receive dividend. Whenever dividend is declared by the company, member have a right to receive dividend. The shareholders of the company have a right to receive dividend when it is declared by the company. If it is not declared, it's not received. You have to declare. First, you have to declare a dividend, and you only declare when company have profit. When company goes into losses, company does not declare dividend. Company only declare dividend when company have profits. In the case of losses, company will not declare dividend. So to receive dividend when declared, that is your right. And to resist yourself and to safeguard yourself against increasing liability without his written consent, that is your right. You can resist, you can be against increasing your liability. You can say, I'm not ready to accept increasing liability in writing. You can give your written consent that I can't accept more liability. So you have to give your written consent and dissent in writing in respect of your increase in your liability if it is increased by the company, in respect of your shares. And if it is not acceptable to you, you can give your application in writing, consent, dissent in writing to the company. That is your right. That is your right to safeguard yourself against increasing liability. And without your written consent, if it is increased, then it is your right to file an application, send an application, write an application to the company that I'm not ready to accept this liability, increase in liability, and it is against my consent. I'm giving my dissent on this, and with your signature and all. So you can submit. That is your right. You can anytime you can submit an application, and, appeal to the company that I can't take over this liability as increased on me without my consent. I'm giving a dissent on this. So you can write an application, and to have rights share. That is Section 62 gives you a right to have right shares. Section 62 of the Companies Act 2013. To appoint directors, Section 152 of the Companies Act to appoint directors of the company. Uh, that is your right to appoint as a member of the company. You have right to appoint directors of the company, and to share the surplus assets during the time of the winding up of the company, or you can say dissolution of the company as per Section 320 of the Companies Act 2013. So these are the certain rights available to you, and you can exercise these rights as a member of the company. Uh, till your name is registered as a member of the company, you can exercise those rights. You can appoint directors of the company, have a say in the appointment of directors of the company. You have a right to share a surplus assets during the time of the winding up of the company, or you can say dissolution of the company, as per section 320 of the Companies Act 2013. So these are the certain rights available to the members of the company as per section 96, section 100, section 105, 107, section 44, section 56, section 62, section 162, section 320. So these are the rights uh, available to a member. Then come to the again the continuation of this rights of a member. Rights of dissentient shareholders to apply to tribunal. Tribunal here means the CLT and CLT. NCLT is a National Company Law Tribunal, Section 48. Right of dissentient shareholders who have given their dissent on any uh, in any terms or any on any case. So you have a right to appeal, apply to tribunal, a right to make an application collectively to tribunal for relief in cases of operation and mismanagement. If you find something insider trading happening inside the company, if you find some gambling is happening inside the company, some mismanagement is there, some fudging of account is there, manipulation of accounts is there. If you see some fraudulent element is there, fudging of account is there, and you say some they are playing some game inside the company, some that is not acceptable. In that case, you can collectively, the members in collectively also make an application to the tribunal. Tribunal is a court. Tribunal is a court. Earlier it is a CLB, Company Law Board, now it is tribunal. So tribunal is a court where you can file an appeal to relief in certain cases of operation and mismanagement by the company as per section 241 of the Companies Act 2013. So right of dissentient shareholders who have a dissent in any particular case, any particular issue, that we have seen this happen inside the company. On that basis, we filed an application to the tribunal that provides some relief on these cases that has happened. We want to change in the management. We want to so the shift in the management. We want some judgment on these operation cases and mismanagement cases on the side of the tribunal to get some relief on these cases of fraud element is there. 420 cases are there and they happen in the company, and company indulge in these 420 cases. So if you have any information as a member of the company, it is your duty as a paid investor or member of the company to inform the tribunal that this happened inside the company, so that the tribunal can take certain action against the management of the company and issue the order of the removal of directors of the company, or suspension of their place of office, or restitution from the place of office. Immediately, the directors of the company have to vacate their place of office after the issue of judgment by the National Company Law Tribunal. So this is as per section 241, right of dissentient shareholders to apply to tribunal. Tribunal means already specified. Tribunal means court. Tribunal means NCLT. That is National Company Law Tribunal. Then right to file cases, class against class action suits before the tribunal, section 245. Class action suits are filed by particular class shares, and they are told in class they are filing suit before the tribunal against the company or against its directors of the company or management of the company. So that is by the particular class of shares, that is a class actions suits before the tribunal. Then Section 72 of the Companies Act 2013, right of nomination, that is your right to give nominations. Uh, that is decides exercising by you, given to you by the company. Then right to file a suit or take any other action in case of any misleading statement or the inclusion or omission of any matter in the prospectus. So this is your right. This is your right. If you find any misleading statement in the prospectus or statement in your prospectus, you find any inclusion in the prospectus or omission of any matter in the prospectus that is not true, inclusion in any matter that is not true, that is not valid, and that is mentioned in the prospectus of the company, you can inform to the tribunal in respect of that. If you found any matter omitted from the prospectus of the company or statement in the prospectus of the company, in that case also inform to the company law board or nowadays tribunal NCLT that this happened inside the company. Company use misleading prospectus to subscribe into the shares capital of the company, get subscriptions and a public subscription into the share capital of the company, and company is issuing these misleading prospectus or misleading statement. That should be informed. It should be informed to the uh, tribunal, National Company Law Tribunal, uh, by the member of the company. This is a right available to you as per section 37. Then come to the class rights. Class rights, that is, the member rights, are determined by the Companies Act, memorandumization, articleization of the company, and the terms of issue shares. These are the determined by the. It should be a right to know. You should right as a member right. That is determined by the Companies Act 2013. Your right also mentioned in MOA of the company, A of the company, and your terms and conditions of issue shares. Uh, and that is a right attached to each class of shares. That is also mentioned in your class rights. Meaning is that right attached to each share. That is also mentioned in your certificate and your share certificate. So you should know as a member of the company, as a shareholder of the company, you should know your rights as a member. Then you can avail. Otherwise, how can you avail the right if you don't know? This is my right. First, you know your rights, no? Then you are liable for that. Then you are responsible for that. If you don't know what are your rights and to whom you are, then how can you know that this I can avail, this I can avail? Then that makes you liable and that makes you responsible for that. At least you should know. As a member of the company, you should know what are your rights. What are your rights, what you can avail from the company, and what are your liabilities also as well towards the company. So you should know your liabilities as well as a member of the company. So next topic of this is liability of a member. Rights we have completed. Then come to the liabilities of a member. So liabilities of members of a company depends upon the nature of the company. Unlimited company, every member of such company is liable for all debts contracted by the company during the period when he was a member. So unlimited company, in that case, every member of the company is liable for all debts contracted by the company. That is unlimited. Meaning is that their personal property, their personal assets, their personal belongings can be utilized to pay off the dues of the firm. So every member is liable for all debts contracted by the company during the period when he or she. She is not mentioned in this, but she is also there. She can be a member, but we have only written he was a member, so she can be a member. So he or she, whosoever is a member of the company, have a right, is liable, not a right, it's not a right, is liable for all debts contracted by the company during the period in which he or she is a member. However, company being a separate legal entity concept, No member shareholder can be proceeded against directly by the claimants or the creditors. So their liability, unlike partnership firm, is not joint or several, because in the case of partnership firm, liability of the member is severally or jointly they are liable for the debts of the partnership firm, or equally shared among the partners of the partnership firm. But that is not in the case of company, because company's liability of the members, although it is mentioned limited, but in the case of unlimited company, liability is limited. Liability is limited. The directors, creditors cannot claim directly to the members of the company. They first impose liability on the company, then paid by its members of the company. Again, liability of a member, company limited by guarantee. Every member is liable to contribute to the extent of the amount guaranteed by him, which is given in the liability clause of the memorandum. So, company limited by guarantee, every member is liable to contribute the amount which he or she is guaranteed to the company to be paid at the time of winding up of the company or dissolution of the company, and for that amount that member is liable to pay as a guaranteed amount. So this is a company limited by guarantee. Okay, so you have to contribute during the time of winding up of the company, during the time of dissolution of the company. So, as a member of the company, it is your liability to pay the amount uh, guaranteed by you at the time you become a member of the company, at the time you become the shareholder of the company. So, which is guaranteed amount, and this is your liability as per the liability clause of the memorandization, that is mentioned in the liability clause of memorandization. The liability of the member is limited by guarantee. Then come to the company limited by shares. So majority of the companies belong to this category. So in the case of such companies, the liability of a member is limited to the amount unpaid on the shares held by him. If he has paid full amount on shares, his liability is nil. So, majority of the companies belong to this category. In this case, such companies, the liability of a member is limited to the amount unpaid by shares held or by him or her. So he is only liable to the extent, to the amount not paid by them on the shares, not beyond. So liability is limited up to the extent of unpaid capital, unpaid share capital on the shares, not beyond. They are not personally liable. Their liability is limited. The liabilities of the member is limited up to the extent of unpaid amount, not beyond that. So if he has paid full amount on shares, his liability is nil. If you already paid total amount due on your shares, your liability becomes nil. So nothing you have to pay at the time of dissolution of winding up. You already paid your amount, so your liability is nil. Then come to the register of members. Uh, as per according to section 88 of the Companies Act 2013, point number 1, every company shall keep and maintain the following registers as may prescribed, namely, number 1, every company has to maintain the registers to keep a record of their members of the company, shareholders of the company, employees of the company, directors of the company, the executive directors of the company, non-executive directors of the company, board members of the company, trustees of the company. So you have to keep records of your activities, and you have to keep record of your activities in registers. You have to prepare registers of members indicating separately for each class of equity share capital, preference share capital, held by each member of the company, residing in and outside India. So you have to keep record of each and uh, every member of the company holding a number of shares, of equity share capital or preferential capital um, in the company, and that should be recording. That should be recorded in records, in the register uh, by the company uh, for its members. So each member, whether she is residing in India or outside India, his or her record should be maintained by the company in the register of members, uh, uh, and it should mention the class of equity share capital or preference shares held by each member of the company, whether he or she is residing in India or outside India. Then a register of debenture holders should be prepared and should be kept at the register office of the company. So then come the register of any other security holders that should be maintained as per Section 88 of the Companies Act. Any other security holders of the company, it should be kept and maintained by the company. Then every register maintained under subsection 1 shall include an index of the names included therein. So it should be maintained. The register should be maintained. It should mention the name of the shareholders of the company, name of the debenture holders of the company, name of the security holders of the company, and indexing should be there. Indexing is there, serial number is there, numbering is there, so I can easily find out the name of the shareholder, name of the member of the company for inspection, investigation, verification purposes. So indexing is very important part of maintaining the register of members. Indexing of the names, either alphabetically or non-alphabetically numbering is there, or it should be indexing is there. Then register index of beneficial owners maintained by a depository. These should be kept by the company as per Section 88 of the Companies Act 2013. The following registers must be properly maintained and kept by the company and can be inspected by the members of the company uh, for investigation verification purposes by payment of nominal fees to the company, or it can be only be inspected at the ROC office of the company, registrar of companies, by payment of nominal fees to the ROC of the company. If a company does not maintain a register of members as stated above, as we stated, it should be maintained by the company. Register of members, its members, number of shares hold or held by him, class of shares hold or held by him. If it is not prepared, does not maintain, the company, that is penalty provision is there. The penalty provisions are there. The company and every officer of the company who is in default shall be punishable with fine which shall not be less than 50,000 rupees, but which may not extend to 3 lakh rupees. And where the failure is continuing one, in case of continuing offense, with a further fine which may extend to 1,000 rupees for every day during which the default continues. So, okay, these are the penalty provisions if you're not kept or maintaining register of members as per the provisions of the Companies Act 2013, and you're not complying all the guidelines as stated in that particular act. In that case, whosoever officers of the company responsible for non-compliance of the section provisions of the Companies Act, and whosoever is in default of preparation of the register of members, and that person is punishable with fine which shall not be less than 50,000 rupees, but which may extend to 3 lakh rupees, where if there is continuing offense with further fine which may extend to 1,000 rupees for every day during which the failure continues. So you have to pay fine 1,000 every day till you continue the offense of not keeping, not maintaining the register of members of the company for the record purposes, for the information purposes, as demanded on request by the members of the company on payment of nominal fees to the registrar office of the company, then you have to pay the consequences. You have to pay for the consequences of non-preparation of the books register of members of the company. Then, as per companies management and administration rules 2014, provides entries in the register, and it should be as per section 88. It shall be made within 7 days after the board of directors and duly constituted committee approves the allotment and transfer of shares. Entry should be made in the register under section 88. And within 7 days after BOD or duly constituted committee approves the allotment and transfer shares, it must be recorded, it must be registered in the register of members as per the company's management and administration rules 2014. So this is point number one. Point number as per section 88 of the Companies Act 2013, it should be done within 7 days after constitution of duly constituted committee of BOD and it approves the transfer and allotment of shares. Then you have to make a record of each and every um, transaction in respect of allotment of shares, in respect of transfer of shares uh, into the register of members of the company. Then where you keep your register, where you place your register, the keeping, the place of keeping your register, where you find this register of members as a member of the company, as a shareholder of the company, where you find this register of members. Uh, so the place of keeping the register of members shall be maintained at the registered office of the company unless a special resolution is passed in general meetings of, of the company. So special resolution has to be passed in the general meeting for deciding the place of keeping your register of members of the company. Uh, for every decision in the company, you have to pass a board meeting. Every matter of the company should be discussed in the board meeting. You cannot pass it on its own because company consists of so many members of the company, so many employees of the company. Without their consent, you cannot take any decisions. So where you keep the records of the company, you have to decide the place of keeping the records of the company. uh, then we can know where the records are available so that we can see and we can go and verify the records on request to the company and request to the concerned officials of the company to see the records of the company. The register shall be maintained at the registered office of the company unless this is official guideline. Unless a special resolution has been passed for keeping the register at any other place. If you want to keep your records from Delhi to Jaipur, you have to pass a resolution in company meetings that you want to keep records of register from Delhi to Jaipur. Otherwise, you cannot keep your records in Jaipur. For that, resolution has to be passed in general meetings of the company, and meeting authorize you, and that must be mentioned in the minutes of the meeting that you want to wish to keep your register of members and any other important documents of the company from Delhi to Jaipur address. So you have to pass a resolution for that. So inform. The meaning is that you have to inform other members of the company, and for that your meeting has to be conducted. Meeting has to be, and it has to be notified to others. Then you can make a changes in your place of keeping the books of members. And in any other place, the city, town, village, in which registered office of the company is situated, or any other place in India, in which more than one tenth of total members entered in the registered members resides. So you can keep your place of recording, place of holding the accounts, any other place of uh, but within the state or within the town in India. Uh, then changes in the register of members. So any changes in the entries. Uh, so any changes in the entries, changes in account of forfeiture of your account, buyback of your accounts, reduction in a share capital, issue of sweat equity share capital, transmission of shares, transfer of shares, uh, issue of shares under employee stock option scheme. That should be recorded. That should be recorded, and that should be keeping records into the registered members at the registered office of the company or any other office of the company which company authorized to keep its books of accounts of the company and any other important documents of the company. On that place, the company can keep books of its members by keeping noting their changes on account of forfeiture, on account of buyback, reduction of share capital, issue of certificate share capital, transfer of shares, transmission of shares, or issue of shares under price stock option scheme. It shall be recorded. It shall be recorded. Otherwise, there is no meaning of that. Preparation of books of accounts and all. So it must be recorded. All the changes in the entries, in the accounts of the holder of the company, shareholder of the company, members of the company, it must be recorded in their register. In the front of their names, they mention the register, in respect of their forfeiture, in respect of their buyback, in respect of their reduction, in respect of issue of certificate shares, transmissional shares. It must be on records. So anytime when you wish to see the records of the company in respect of members of the company and the details, everything is available at the register office of the company. You can see the details. If nothing has been mentioned, if the accounts, if the details has not been updated by the company, then how can you see the changes in the records? It must be updated. The records must be updated of the members of the company on regular basis by the company so that we can um, keep records in a proper manner. Otherwise, it is very difficult for the company to find out the proper records of its members of the company. And whatever changes are done in the accounts of members of the company, yeah, it must be recorded within 7 days after the approval by the board or committee. So the company shall make necessary entries in the index simultaneously with the entry for allotment or transfer of any security in the register of members. In case of shares held by trustee, so how can you record? This is a recording of transactions of members of the company in the register of members. So in case of the shares held by a trustee, a declaration specifying the name and other particulars of the person who holds the beneficial interest in such shares must be filed with the company. So, as per Rule 9 of the Company's Management and Administration Rules 2014, the said declaration shall be filed within a period of 30 days from the date on which his name is entered. So, declaration has to be submitted in person who holds the beneficial interest in such shares, and it must be filed with the company as per Rule 9 of the Company's Management and Administration Rules of 2014, and it said declaration shall be filed within a period of 30 days from the date in which name is entered in the name of the uh, members uh, of the register. So, in case of this is a the case when shares hold or held by a trustee, it must the register must specify their names and declaration of a particular person who holds interest in such shares, and as per Rule 9 of the company's management administration rules, the said declaration must be filed within a period of 30 days from the date in which his name is entered. Then there are certain penalty provisions, non-compliance of the Companies Act, Section 88, Subsection 5. So some punishable offences there, penalty provisions are there. And if company does not maintain a register of members or fails to maintain in accordance with the provisions of the Companies Act, the company and every officer of the company who is in default shall be punishable with fine which shall not be less than 50,000 rupees, but which may extend to 3 lakh rupees with the various continuing one, with further fine which may extend to 1,000 rupees for every day after the first during which the failure continues. So you have to pay fine every day, 1,000 rupees every day till default continues. You have to pay the consequences of non-following of the provisions, non-following of the compliance of the Companies Act as per the provisions of the Companies Act. If company does not maintain the proper register and does not updated the entries in the register of members as per the uh, recent changes in the membership, their transfer of shares, in respect of change in the class of shares, in respect of purchase of new shares, in respect of transfer of old shares, that must be recorded, that must be updated in the register of members in front of their names. Entries must be updated. If it is not updated, then it means that it is not as per the terms and conditions of the Companies Act. The records must be properly recorded on time, and it must be updated on time so that we can know the updated records, not the uh, not updated records. So it should be properly recorded, and copy of this must be submitted to ROC, must be kept in the registered office of the company for record purposes, and any person of the company, any shareholder of the company can see this copy, can demand to see the register of members of the company on payment of nominal fees of the company after payment of nominal fees to the company. So, then come to the rule number 3, subsection 2. Every company not having share capital is required to maintain the register of members with the specified particulars in respect of each member. So we have to maintain, every company has to maintain, not having share capital is required to maintain register of members and with specified particulars in respect of, you have to mention the details, particulars in respect of your members of the company as per Rule 3, Section 2. Number of detail is personal details such as name, address of the members of the company. Then number 2 is date of becoming member. This is as per rule. This is you have to mention as per rule date of becoming a member of the company. Then date of situation of member of the company, the date when he ceases to become a member of the company, that date should be mentioned in the register of members. Then amount of guarantee, if any, this should be mentioned in the register of members of the company. And any other matter of interest, if any, you can mention the register of members of the company in front of their names. Then instruction given by members with regard to sending of notices as per Rule 3, Subsection 2. Uh, So by this, today we wind up the session about the how to keep, how to maintain registered members of the company, and penalty provisions are there, legal compliances are there, respect to occupation of the registered members. You have to keep records of registered of your members, and you have to update your records on regular basis so that we have the updated records of each and every member of the company. So anytime you can see the records for inspection purposes, for investigation purposes by the company. So by this we wind up today's session of register of members. Thank you.